I welcome you all to today's virtual program, lecture meeting on the Constitution of India. What are the rights of a professional? And in fact, the Constitution has a balance. It talks about rights as well as the duties of a citizen also. So, being an Indian citizen, prima facie, it is our duty that we should at least know what the Constitution says, and more particularly, being professionals like chartered accountants, it is more important to have at least the basic understanding. And of late, I was just talking to Brijesh Bhai. Now the institute has also introduced one of the elective subject, though it is not one of the compulsory subject, but as a Constitution of India is one of the elective subjects. And I welcome you all and wish you all a happy learning about the Constitution of India. And more particularly in the month of January, on 26th January, we'll be having our Republic Day commemorating the formation of our Constitution. I welcome the faculty, all the participants, and hand over the charge to the committee chairman, Karan. Thank you, Karan, for organizing such a wonderful seminar. Over to you.
Yeah. Good afternoon, everyone. So yeah, again a unique program under PD committee this year. So this year we have done a lot of programs on wealth planning. We have done lecture on options and futures, and last lecture of Shri Anup Shah, who traveled from Mumbai, and more than 100 participants listening to him on succession planning was a huge success. So with that, and we also had a lecture on opportunities in Dubai. So again, continuing the tradition, we have today a lecture on as Riken Bhai introduced, on the Constitution of India. And we have our expert faculty, Brijesh Bhai, for whom this is so as I understand, this is an area of keen interest for him, and he would like to share his insights. So again, it's always nice to hear someone who is very passionate about a subject that affects all of us. So today we have a subject like that. About Brijesh Bhai, I think most of you know him because he is a regular faculty in GST, and most of you would have heard them. But I'll give a very short introduction of him. He is a CA national rank holder. He has earlier worked with Deloitte and EY, and he is of course an advocate. So he mainly deals in tax litigation matters, and he represents to represents to different appellate forums, and he goes to High Court as well. And he likes to deal in cases involving FEMA also. And apart from Gujarat, he has represented clients in other states also, like Rajasthan, UP, and Karnataka. So, and we have generally heard him in GST. So he has been a faculty for GST for ICAI and even for revenue officers. And he has also co-authored books on GST. So with this very brief introduction, I think we would now invite Brijesh Bhai to start his lecture.
Thank you very much, Ketanji. Before I start, a small correction in the introduction. He has mentioned that I am an advocate. I am at present not an advocate. I am a lawyer, but not advocate. So
okay.
I go to High Court just to accompany my wife. She is an advocate. I draft writ petitions. I brief her, but the matters are being argued by my wife. Yes, I am a lawyer. I have the law degree. I am a university rank holder in law, and Constitution is a matter of interest for me, a subject of interest for me, but not to be confused with whether I am an advocate or not. At present, I am not an advocate. I have not taken the sanad. I have not surrendered my CA-COP. So that is the thing. As far as the subject is concerned, I had one discussion with one of the chartered accountant friends before 1 week. He said કે તમે આવો છો અમદાવાદ CA માં lecture લેવા માટે તો આપણે મળીએ. So I said કે but you come to attend the session also because it is for chartered accountants. Then he said કે we don't need to attend this session કારણ કે આપણે તો કંઈક ખોટું કરવું જ નથી. આપણે કંઈ ખોટું કરવું નથી એટલે આપણને આ સબ્જેક્ટમાં જાણવાની કંઈ જરૂર નથી. So there the thing strike in my mind why people are not that much interested in listening about the constitution, because જેણે ખોટું કરવું છે તો કદી સાંભળવાનું જ નથી, નક્કી છે. And we have this impression in our mind if we are doing everything in a perfect way, in an ethical way, in a legal way, then we are not required to understand our constitution. Then we will not be required to be to some, we are not going to fall into some trap. So one answer will be that even if we are doing everything perfect, everything legal, everything ethical, there is no guarantee that we will not be trapped into some of these kind of things, because recently there are many cases specifically from the execution authorities like government. They are trying to portray a picture that when any professional advises client about something, then he is taking the full responsibilities. Now collusion is assumed that if client is doing something wrong, then his chartered accountant or other professional, whosoever is there, that particular person is involved into any kind of fraudulent activity and those kind of things. As far as constitution is concerned, constitution does not differentiate or discriminate between a normal citizen and professional. So whatever rights are given to normal citizens, the same rights are given to professionals. We do not have any special privileges or special rights. So we need to understand what are the rights given to citizens as well as some of the non-citizens. But there are certain Supreme Court judgments and some High Court judgments also which are covering this specific topic, that where we can protect the professionals who are working in their professional capacities. They are not colluding with the clients, they are not involved into fraudulent activities, but still there is an assumption that these people are involved into some, let's say, financial fraud, etc. Then how to protect them? This is the thing. When this subject was given, I think this subject I am taking for 10th or 11th time into different professional forums. That is also a very good thing. Reason being, when first time I took this particular topic, I had a doubt that who will listen this particular topic, especially chartered accountants. Why they will listen this kind of topic? If a topic is given to me like, let's say, critical issues in GST, or let's say annual return filing 9 and 9C, this kind of thing, the chartered accountants will be more interested. But listening to the basic things like fundamental rights, and if this many people are, even if let's say right now I'm seeing that 30 participants are there, so even 30 people are listening to Constitution of India is a very good number. Mostly I don't expect more than 10 people to attend about some or want to attend something about Constitution of India. I had an impression we will have a small group and we will discuss the things. It will be more interactive. But there is a limitation of this platform, online Zoom meetings, where we can have a limited interactive session. If the host permit, and if you are willing, then we can discuss the things also. So we may not keep it one way, because what are the problems faced by chartered accountants? These problems are not standard problems. Different chartered accountants or different professionals are facing different kind of problems. So we can do one thing in between. If you have something to add, I will not say if you have some questions we can always take. If you have something else to add, or if you want me to go into some other details about Constitution, about the legal issues, how the High Court functions, or how the Supreme Court functions, or how these kind of things are coming to surfaces and how to deal with those issues, then I will be more than happy to accommodate those kind of things also. As far as today's topic is concerned, I have bifurcated the things like this. That first of all, we will discuss some basic, absolutely basic things about the Constitution. Like when, let's say, a first year LLB student goes to college and he attends the normal lecture about Constitution. What are the basic things? Fundamental rights will be there, duties will be there, these kind of things, rule of law, separation of powers. We will take some time to understand these things. Then we will jump to the issues faced by the chartered accountants. Then we'll try to link both these things. Then we will verify the arrest provisions under GST, arrest provisions under PMLA, and in case of arrest of, let's say, some of your clients, or let's say in case of arrest of a chartered accountant also, what kind of precautions we can take, or just to save ourselves from this kind of issues, what kind of safeguards are available, these kind of things we can discuss. So this is how we want to go. If anyone has anything to add, let's say, please take this specific issue, then right now also we can open the things for discussion. If afterwards you want to add, then that also will be fine. So whatever the host suggests.
We can invite the queries or discussion into the chat box.
Okay.
Yeah, and I think Jitubai will allow anyone, if they want to unmute, so they can unmute themselves and add if they want to, talk with the faculty. And
Yes,
as he is
member can
clearly
add,
saying that he wants an interactive session, so if someone wants to interrupt and talk with Brijesh Bhai, they can just unmute themselves and speak.
Okay. One more thing will be there. Whenever I or anyone else speak about the constitution or law, is always subjective. Things will keep on changing. So whatever your questions will be there, I can give my opinion. Definitely I will give my opinion, but don't consider that thing as a final thing. Because the civil jurisprudence and criminal jurisprudence both are absolutely different things. What happens in criminal jurisprudence is something that is beyond our imagination sometimes. So always better to consider these things as opinions. So now let me share my screen. So the presentation that I have prepared, that we can discuss. Is it visible?
Yes, it is visible.
Okay. So fundamentally we are talking about the constitution, but in constitution we are talking about the fundamental rights, and in fundamental rights we are specifically talking about the things which are affecting the professionals. So those kind of things we are going to discuss. Let's start with the basic. What is constitution? Now you all understand this thing, that constitution is the foundation of any law which is passed by the parliament or the state assembly. So whenever any law is passed or any law is drafted, any law becomes effective, that must be within the limits given by the Constitution of India. Nothing can go beyond Constitution of India. There is one part called Part 3 of the Constitution, which talks about the fundamental rights. There they have defined state under Article 12. In Article 13, they are saying that whatever laws will be passed or whatever laws will be made, that must adhere to this part of the Constitution, Part 3. Any law, any provision which is against the provision which is given under Part 3 of the Constitution, that will be considered as invalid. This has been given in Article 13. So Article 13 says that if you violate this part means Part 3, and Part 3 means fundamental rights. So if you violate Part 3 of the Constitution, that means that particular law will be an invalid law to that extent. This is what we can understand. Now, Riken Bhai was talking about the fundamental rights are also there and fundamental duties are also there in the Constitution. Any one of you can tell me, just unmute and you can tell me what is the difference between fundamental rights and fundamental duties as far as Constitution is concerned. Anyone? Is there a difference between fundamental rights and fundamental duties?
Fundamental rights are guaranteed by the Constitution.
Okay. And fundamental duties?
Are voluntary or obligatory?
Yes. So just understand, the Constitution has not imposed any duty on us. They have given the list which is in the non-operative part. part 4 of the Constitution, which is not an operative part. Non-operative part means if you violate that particular part, then nothing will happen. So let's say some of the fundamental duties, whatever are given to you, and you are violating that particular duty, then the state cannot drag you to court, except in some situation. Which situation? Let's say they are saying that protection of environment is the fundamental duty of each and every citizen. This is what has been given in the Constitution, fundamental duties. Now let's say protection of environment laws are passed in India, where they are saying that more than this much decibel noise pollution you cannot make, this kind of pollution you cannot do, this kind of laws are passed. So if you are violating that particular law, then action can be taken against you. But if you are, let's say, violating the fundamental duty per se, then there is no action that can be taken by the state. And rightly so. Because let's say if state imposes duties on us, that will be very much a kind of threat for us. Because whether I have fulfilled that particular duty or I have not fulfilled that particular duty, that is a subjective thing. So no duties are actually imposed on us. They are saying that this is the expectation from each and every citizen, that you should do this much things. But if you don't do it, it is not enforceable. It is under the non-operative part. Whereas part 3 is very much enforceable, very much operative. Under part 3, the fundamental rights are given. The moment fundamental rights are violated, you can directly approach to High Court or Supreme Court that my fundamental rights are violated. Now, if your fundamental rights are violated, then High Court judges will normally not say that, see, these are other remedies available with you. That you file an appeal, go to tribunal, do this kind of things, X, Y, Z, etc., etc. If you can clearly establish that even by issuance of this show cause notice, my fundamental rights are violated, then directly you can approach the High Court or Supreme Court. So the remedy of violation of fundamental rights are approaching the constitutional courts. Constitutional courts means our High Courts and our Supreme Court. This much things we understand. Let's go ahead. Rule of law. Yes, how the Constitution works, on which fundamentals or on which basis. Just a second. This fundamental rights, or let's say any other provisions of the Constitution are based. It is based on rule of law. Now, what is rule of law? Rule of law means law is supreme. We also call it supremacy of law. Supremacy of law means the execution, or let's say we call it the day-to-day work of running a country will not be as per the wishes of any individual. That individual may be a chief minister, that individual may be a finance minister, that individual may be a prime minister, anyone. It will not be as per the individual wishes of that person. It will be as per law. So that is called rule of law. Law will prevail over each and every assumptions and presumption and wishes. So law is supreme. This is what the concept of rule of law is saying. So rule of law is a fundamental basis on which our Constitution is drafted. Now here we call it everyone is equal before law. And I also added that protection for professionals. So if everyone is equal, that means you cannot discriminate between a professional person and a normal person. So the rule of law is fundamentally, they are saying that it ensures, regardless of position or status, that everyone is abide by the law. This is the concept of rule of law. After rule of law, we understand the separation of powers. Why we are discussing these things? Because we are starting from the basics. So separation of powers. Now, what understand in government, we have 3 pillars which runs the country: legislature, executive, and judiciary. Now here in executive, we have called, in bracket, we have written that government, but ultimately government comprises of the 3 legs or 3 pillars. Now legislature means what? It can be parliament also, it can be state assembly also. They have the powers to draft the law. to pass the law. These powers are given to legislatures. Now, executives are not required to draft any kind of law. They will simply execute whatever law has been drafted by the parliament or state assembly. This is their job. Yes, of course, there are certain law in which the parliament is saying that this is the main provision. Now, how this will be executed, what will be the detailed rules of these particular things, that will be drafted by, this will be drafted by the rules. If this will be drafted by the rules, that means the role of government or executives will come in the picture. That means state government or central government can do those things. Another thing, judiciary. Now, what is the role of judiciary in this framework? Then judiciaries will see that whatever execution has been done, it has been done as per the law passed by the parliament or state assembly, and whatever law is passed by the state assembly or the parliament is as per the Constitution of India. So judiciary is having the supervisory role. Judiciary is basically the constitutional courts. We call it Supreme Court, we call it High Courts of India. This Supreme Court or High Courts are the protectors of the Constitution. These judiciaries are the protectors of the Constitution. See, so our Constitution is protected by these courts. Now, protection from whom? It is a protection from the state, mainly from the state. So any, let's say, execution overreach, any kind of, let's say, the legal drafting overreach, all these particular kind of things will be checked by the judiciaries. This is how this Constitution has been framed. 3 legs, rule of law, the separation of power, everything. Up to this stage, we are clear. Then we can go ahead towards the fundamental rights. Let's go towards the fundamental rights. Now, as I was saying that fundamental rights are given under Part 3 of the Constitution. These are the fundamental rights given to you. Now, which fundamental rights are given to us? Right to equality. Article 14 to Article 18. Now, all these rights are not going to be discussed by us because whatever things are touching the professionals, that we are going to discuss in detail. Article 14 is basically the protection against the arbitrariness and discrimination. 15 is discrimination based on caste, creed, gender, etc. These kind of things are there. In the same way, we have Article 16, Article 17, Article 18 we have. This 16, 17, 18, these are exploitation, untouchability, abolition of titles, all these kind of things are there. But ultimately, they are talking about the same thing. In summary, that everyone is equal before the law. This equality we are going to discuss in details because it is ultimately touching the professionals. Another thing is about right to freedom, Article 19 to 22. Here also one specific article is the 19(1)(g), which is the right to practice a trade or profession that we are going to discuss. Article 21 is right to life and personal liberty. Article 20 will be there. Article 22 will be there. These are some of the things where a person is arrested. What are his rights? These kind of things are discussed in this 20 and 22. So this right to equality and right to freedom, these are our fundamental things that we want to discuss. Then right against exploitation, Article 23 to Article 24. Right now, there is a huge debate going on LinkedIn and other professional platforms about working for 70 hours and that 90 hours debate. So ultimately, it is a kind of exploitation. So the protection against exploitation is given under Article 23 and Article 24. So it is not our today's topic, but if we start talking about the right against the exploitation, that will also take another 1 hour. We are simply going to skip it. Right to freedom of religion, Article 25 to Article 28. Now, freedom of religion, you can choose your religion, you can practice your religion These things are given from Article 25 to 28. Cultural and educational rights are given in Article 29 and Article 30. And finally, right to constitutional remedies, Article 32. If these rights are violated, then you can approach Supreme Court under Article 32. Now, anyone can tell me that we have discussed Article 14 to 32, or we have seen the summary. One article is missing here. Article 31. Why this particular article is missing? Anyone? Okay, let me tell you. It is repealed because it was right to property. Article 31 was right to property. Now, by the 44th Constitutional Amendment Act, this Article 31 was repealed. It was removed from Part 3. That it is your right. It's a legal right, but it's not fundamental right. So your property, because what happened at that particular time, the landlords were having huge land and the farmers were cultivating that particular land. So as a revolution of, let's say, socialism kind of things, where this land were required to be given to farmers, it were required to be snatched away from the landlords. So if right to property is a fundamental right, it cannot be snatched away from them. So they said that for properly implementing or properly having this equality concept in practical scenario, this Article 31 doesn't fit in the fundamental rights. We give it as the legal right, but not as fundamental right. So in some of the situations, Parliament can pass a law, they can take away your property. So for doing that particular thing, Article 31 was removed from the list of fundamental rights by 44th Constitutional Amendment. Now then there was a huge debate that by constitutional amendments, whether you can remove these fundamental rights or not. Because what happens ultimately, now a small academic discussion, but it is very interesting discussion. That's why we are taking this particular issue. Now, the way in which this Article 31 was removed, there was a big question mark. That let's say today we are saying that government cannot pass any law which is not consistent with Part 3 of the Constitution. Not consistent with Part 3 of the Constitution means what? It is violative of your fundamental rights. But if let's say government or let's say parliament or let's say state assembly passed a law, because ultimately Constitutional Amendment Act is also law, and says that this right to equality is removed or right to freedom is removed. Now question remains, your Article 13 says that no law, please understand this is very interesting, no law which is not consistent with this part can be considered as valid law under Article 13. Now this part means fundamental rights. Now they pass a law under Article 265 of the Constitution, because Article 265 of the Constitution gives right to Parliament to amend the Constitution. If some of the things are required to be removed, simple majority law is required to be passed. If some exceptional things are required to be changed, then 2/3 majority is required. Some more exceptional things are required to be changed, 2/3 majority in Lok Sabha, Rajya Sabha, and is required to be ratified by all the state assemblies. These kind of things are given under Article 265. By exercising this power, suppose let's say tomorrow, if they remove right to equality, then whether they can do this thing or not, that was the question. Then a huge debate was there. Golaknath case came. Then after this, Keshavan Bharti versus State of Kerala case came. In the State of Kerala versus this Keshavan Bharti versus State of Kerala, 13-member largest constitutional bench decided that the Parliament has the right to amend the Constitution, but it cannot rewrite the Constitution in the name of amendment. Meaning thereby they can change the constitution, but they cannot change the fundamental character of the constitution. Now, if they remove right to equality, it changes the fundamental character of the constitution. That is not allowed. So they said that these are the basic characters of the constitution. They gave the examples, which can never be changed by even 100% majority by the Lok Sabha, Rajya Sabha, and all the state assemblies. So this is what happened after removal of Article 31. So right now we can say that we are safe, that whatever will be the majority of any government, they cannot change the fundamental character of the constitution. Now let's come to Article 14, equality before law. Equality before law, see, one more thing was there in the fundamental rights. The fundamental rights normally you can enforce against the state. Against the state means against the central government or state government. But there are certain fundamental rights which you can enforce against the individual person also. For example, let's say Article 21, life and liberty. Now, this Article 21 is not only enforceable against the state, it is also enforceable against the individual, private individual. Same way, some of the fundamental rights are given to citizens, and some of the fundamental rights are given to citizens as well as non-citizens. So there are certain articles in the constitution, fundamental rights, which are the rights given to the citizen as well as a person who is non-citizen. So our Article 14, whatever is that, is applicable to both citizens as well as non-citizens. Though it is enforceable only against the state, but the rights are given to both the Indian citizen also and also person who is non-citizen. So discrimination you cannot do. The Article 14 basically, whenever we draft a writ petition in, let's say, income tax cases or let's say GST cases, we normally say that is violative of what? And in the taxation law, it is normally violative of Article 14, Article 19(1)(g) and Article 21. For example, let's say fundamental rights are violated. We don't go to Article 25 and we don't go to 29 and 30, these kind of things. Mainly it is Article 14, Article 19(1)(g) and Article 21. For example, let's say my GST registration is cancelled because I didn't file my GST returns. So under Section 29 of the GST law, they have the right to cancel my GST registration. They cancelled my GST registration. Now I forgot to go for revocation under Section 30 of the GST. I am giving example of a GST because I am more familiar with the GST law as far as taxation is concerned. Then I also didn't file appeal under Section 107. Time limit of filing appeal is also gone. Then I felt that now this GST number is already gone. Let me apply for another GST number. So I applied for a new GST number. Now the GST officer said that as your previous GST number was cancelled, now I will not give you the new GST number on this PAN. So now the consequence of this action will be, for me permanently, the doors of doing business are closed. Now there is no remedy in the law. In the GST law, there is no remedy. So we filed a writ petition saying that if you don't give me the GST number, then I cannot do business. So it is violative of Article 19(1)(g). Second thing, if I don't do the business, my right to life is also compromised. How will I live without doing business? How can I earn? If I don't earn, then my livelihood will be in problem. If my livelihood is in problem, then my life is in problem. So that is violative of Article 21. So basically, whenever taxation law will be involved, normally Article 14 will come in the picture. For example, right now there was a debate about the Safari Retreat judgment, in which the main issue was this particular issue, the original issue. Though afterwards in the Supreme Court, the issue only remained about the plant and machinery and plant or machinery. But basically they said that if a person is purchasing cement and bricks, etc., and constructing a building, and then after he is giving this particular building on rent, then under Section 17(5), you are not giving him the input tax right. But let's say if the same person is let's say, providing a construction service, then to that particular person, the ITC is available. This is discrimination. To one person, you are giving the ITC of one thing, and to other person, you are not giving ITC of the same thing. That is discrimination. That was the argument. But that particular argument didn't succeed. The reason was there is a difference between discrimination and classification. So there is a concept of parliamentary wisdom. Parliament in its wisdom thought it appropriate to block some input tax credit. And they made a classes that to this kind of taxpayers, this ITC will be available. To this kind of taxpayer, this ITC will not be available. So that is not called discrimination. This is called classification. This is what Supreme Court says. So classification is allowed. Discrimination is not allowed. Now, what is the difference between discrimination and classification? Then the classification will be having some logic behind it. Now, protection of revenue will be a sufficient logic. But discrimination will not be having any logic, or it will not fulfill any fruitful purpose. Then we call it a discrimination. So when there is a discrimination, it will directly hit Article 14. When there is a classification in the taxation law, it will not hit Article 14. This is how we understand these things. So I think Article 14 is clear. Let's go towards some more interesting thing about Article 14. Supreme Court in one case said, yes, you are talking about equality, that is okay. But equality in unequal circumstances amounts to inequality. So if you treat everyone equally, that will not be equality. Because the circumstances of the person, the background of the person, the opportunities which were available to that particular person, those kind of things, whatever were there, if you don't consider those things into consideration, or if you don't take those things into consideration, then you cannot say to be fulfilling the requirement of equality. So Supreme Court categorically said, equality doesn't mean that you treat everyone equal. It means that if a person is having less opportunity, and if you are giving him more opportunity in comparison to the person who is a privileged person, then that is considered as a true equality. The true equality will be having an equality in the unequal circumstances. So if my circumstances are not equal with another person's circumstances, then we cannot be treated equally. So three things I have taken: equal treatment in unequal outcome, equitable treatment, and practical application is legal system must recognize diverse needs to ensure genuine equality. We can give the example, let's say some benefits you are giving to some rural areas, some benefits are given to the backward classes, etc. Then we cannot say that this is violative of Article 14, though there is a specific reservation given to those persons under the Constitution itself. But even in the absence of those things, we cannot say that this is discrimination, because their background, their circumstances were not equal to the circumstances or opportunities given to the privileged class. That's why giving them the more opportunities will not be considered as violative of Article 14. This is how Article 14 we need to understand. 19(1)(g) for us, freedom to practice profession. You can choose your career. So nobody can tell you that you don't do this kind of work. Everyone is free to do whatever kind of work or profession that particular person wants to do. Protection for all professionals. So courts have consistently protected the rights across all levels, from street vendors to corporate professionals. But there are certain reasonable restrictions also. What's the meaning of, let's say, in the reasonable restrictions in public interest? For example, we say that if you want to go into defense, then this much capacity you must be having. So these kind of reasonable restrictions can be imposed. It will not be considered as violation of Article 19(1)(g). Otherwise, you cannot simply say that, let's say, tomorrow state government or state assembly of some X state cannot say that nobody from the Y state can do profession in this state. That is not permissible. If with 100% majority also that kind of law is passed in that particular state assembly, it will not survive the test in the Supreme Court. Court will say that it is a violation of Article 19(1)(g). Nobody can put restriction on doing the trade or profession. Yes, we call Article 21, the legal fraternity call Article 21 as Gangotri of all the fundamental rights. A simple one sentence fundamental right. Nothing more is added here. But it covers everything. Right to life and personal liberty. Right to life and personal liberty means what? This if you read the bare act of Article 21, they are saying that no person will be deprived of life and personal liberty without following the due course. Now, due course of law ultimately means what? Let's say if a person is given a death sentence, then for giving the death sentence, whatever principles are established by Supreme Court, that must be followed. Nobody will be deprived of his life and personal liberty. Now, personal liberty we call, let's say, the right to privacy. Supreme Court has stated that right to privacy is also covered into Article 21. So it is also fundamental right because of Article 21 only. Some other examples also you can give. For example, one landmark case happened where there was an accident and nobody was taking the victim to the hospital because the hospitals were saying that there will be a police case that will be filed, investigation will be done, and then after everything will be done. So Supreme Court said that if a person is injured in an accident, then his first fundamental right is the right given under Article 21, right to life. All your procedures, all police case and everything can wait, but the medical treatment cannot wait. So if let's say someone is injured and is coming to hospital without asking any further question, hospital is obliged to treat that particular person. They cannot wait for the police. They cannot wait for someone to start investigation and anything. One more thing, the question that may come in your mind is these fundamental rights are enforceable mainly against the state. Let's say private hospital is there, where you bring one of the victim of the accident and the private hospital is saying that we will not treat this particular person because first we will wait for the police. Then can you file a case against that particular hospital that you have violated Article 21 because that private hospital is not state? Then please understand, Article 21 is enforceable against the state as well as against the private person. So Article 21 is such a fundamental right which is given to you that you can enforce against anyone, not only against the government. So those kind of things are there. Many other things were there. Right to education, let's say Article 21, capital A, new article inserted. That was also part of Article 21. So right to, let's say, fresh air, unpolluted water, all those particular things are recognized as fundamental rights because of Article 21. You name any right which is not given in other articles, that must be covered under Article 21 as your fundamental right. Now, as we have understood Article 14, Article 19(1)(g) and Article 21, now we can come to our profession. That legal challenges for the chartered accountants and other professionals. We may come to a conclusion as a feeling only that we have derived something through which we can protect ourselves, but that may only be a feeling. It may not be the actual things because circumstances of all the chartered accountants may be unequal. So before I start the legal challenges for chartered accountants, anyone can give any example, or they might have read in the newspaper or from their own or their friends' experience. What are the legal challenges being faced by chartered accountants and professionals, specifically by them? Anyone, so that we can discuss those things first.
For wrongdoing of clients, the professionals are held responsible.
Okay. Wrongdoing of client, the professionals are held responsible. Okay.
And for that reason, they are arrested sometimes.
Sorry?
And then they are arrested also.
Right. Okay. They are arrested also. The professionals are arrested. Okay. Anything, any other problem? See, there must be some reason or some logic of the chartered accountants. Yes, sir.
one of the problem is that just filing GSTR 1 or 3B from our office, and officer are not able to catch the person who is responsible for this. They are charging frame on chartered accountant because they think that they are the mastermind.
Okay. Okay.
Because IP address in filing GSTR 1 and 3B is of chartered accountant.
Okay. 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 So first thing, for wrongdoing of the client, the chartered accountants are being harassed. First thing, they are being arrested. The let's say the most severe consequence will be the arrest of a chartered accountant, right? Yes or no?
Yes, yes.
Yes. Okay. Anything else? Any one of you may be facing, or you might have heard. This is mainly the reason why you are attending this session.
Even nowadays the records of all the clients are being accessed and not confined up to the search of a particular client.
Okay. Before, I think 1 year or 7-8 months, I think there was a case where the lawyer's office was searched by the income tax officers in connection with some of the client, and the Gujarat High Court came down heavily on the income tax authorities for conducting the search at the premises of the lawyer, of the advocate. Okay. Anything else? See, first thing, okay, let me start sharing the screen. The first thing is this, that the issue is severe, no doubt about that. And day by day, we are getting the feeling that we are not safe. The chartered accountant doing the certification work and the audit work, many of the chartered accountants, I know that they are saying that now I don't want to do this work. No certificates will be signed by me. No audit will be done by me, because ultimately there is a huge harassment or a huge risk we are carrying. So obviously we all need to accept this fact that in the modern times, earlier this was not the case. In the modern times, it has become very easy to frame a chartered accountant, or let's say to arrest a chartered accountant also, for the wrongdoing of the clients. Definitely. I have listed some of the things where we may face problem. Number one, first, and not that much severe, harassment by government authorities. CAs are facing escalating instances of being summoned or issued notice for the professional work, even when executed in good faith and adhering to professional standards. Let's say someone is issued to you that how you have conducted this particular audit. Let's say a notice issued to you that give these particular documents of your client, etc., etc. So harassment, ultimately harassment by the government authorities. We are still not about the arrest and everything. Second, unjust inclusion in legal cases. Now, liability beyond scope. CAs are often drawn into legal cases where their role extends beyond their engagement, leading to unfair liability for actions beyond their control. And there is a presumption of guilt. In case of fraud or financial mismanagement by clients, CAs are sometimes presumed guilty without sufficient evidence, impacting their reputation. Okay. Third, assumption of collusion. A growing perception exists, and day by day it is growing more and more, among enforcement authorities, that CAs are colluding with the clients in misconduct, undermining the professional integrity. This presumption of guilt without proper evidence creates a climate of fear and discourage chartered accountants from taking on challenging engagements. Yes, because nowadays what happens, that if you take any engagement, first thing you need to consider is what is the risk, whether I will be framed into anything or any wrongdoing of the client or not. And last severe thing is here, unfair action. Arbitrary actions like arrest for certification audit can occur despite adherence to professional standards. This creates an environment of fear and distrust. So these are the things which are challenging for us. Yes, I have given you the problems, but don't think that I have the solution also for all these problems. I can give you the way forward to avoid this kind of issues, but that may not be the comprehensive solutions. You need to find out your own solution. Please understand one thing, the criminal jurisprudence in our country is such that once a criminal case is filed against a person, then before that particular case comes on trial, only at the stage of trial, it will be verified whether that person is guilty or not. Before that particular thing, a person can be arrested. He is required to file a bail application. His bail application will come on the table on which day we don't know. Up to that particular stage, he is required to be in the jail. So that question that was asked by my very dear friend, chartered accountant, we are not doing anything wrong, then why we need to understand our rights? Please understand, 2/3 of the inmates of the jail, those people who are in jail right now, they are under trials. That means they are not convicted. 2/3. So only 1/3 are convicted people. A person can be arrested without evidence also. The criminal jurisprudence is such. Then after, he will be produced before the magistrate. And if the magistrate feels that there is a possibility of this person colluding or this person doing the fraud or any kind of criminal activities being done by this person, he can approve the remand also or judicial custody also. Then you will go round and round and round by filing the bail application, and you will be trying to come out of the jail. So this is how the things are in our country. So we need to be absolutely clear about those things. That if tomorrow we hear that one person is arrested, don't assume that he is arrested and he has done something wrong, that's why he has been arrested. Because whether a person is guilty or not, that will be decided by the court afterwards at the stage of the trial. Even before trial, the guilt will be imposed on the person. So it is compulsory for each one of us to be prepared, each one of us to have the understanding of the fundamental rights. That's why we are taking this particular session. Now, before we come to arrest, because arrest is a severe provision. Sometimes what happens, another risk we are carrying is the cases of professional negligence. Because professional negligence of two things or of two consequences. Number one, a civil negligence, and second is criminal negligence. In civil negligence, you may be asked to pay the damages. Pay the damages to whom? Pay the damages to the client sometimes if the case is filed by the client. Or to pay the damages to the government also. Because let's say government is saying that you were entrusted with this particular duty, you have not fulfilled your duty, and that's why the government exchequer has incurred this much loss by not collecting the tax or etc. from the client. That's why you are required to make payment of this. Is a civil consequence. A criminal consequence may also be there. Let's say because of your action, the tax evasion is more than 5 crore rupees in GST, for example. So prosecution will be there. Under section 132 of the GST Act, prosecution will be launched on you. In income tax also, prosecution can be launched. So that will be a criminal consequence. Because of professional negligence, they are not saying that you have done this thing. They are only saying that because of your negligence, this thing has happened. So it can be having a civil consequence also. It can be having a criminal consequence also. Now, as far as professional negligence is concerned, suppose I want to file a case of professional negligence against someone. Then which are the things I should prove? Now, let's take it other way, reverse way. If someone wants to file a case against me, or he has filed a case against me for professional negligence, what is the defense that I can take? See, there are certain sequences which should be there. Only then a professional negligence case can be filed against me. Number one, first thing, here we have started with breach of duty, but before breach of duty also there must be one thing, that is the existence of duty, existence of an obligation. That means in the contractual term, I must have some obligation or duty to fulfill. Suppose, let's say, there is no such kind of obligation or duty to fulfill, then there is no question of any kind of professional negligence. Now, let's say first stage, we are saying that there exists a duty or there exists an obligation on me. So first stage is over. Now we come to second stage. Breach of duty. Now, the duty which was imposed on me or the obligation which was there on me, that is breached. I have not fulfilled that. That is also proved. So that breach of duty, second stage also I cleared. Third, there must be some loss or damages. Now, loss or damages to the client or to the government. Now, let's say I had an obligation. I couldn't fulfill that particular obligation, but there is no loss or let's say no damages, then there is no question of professional negligence case to be filed against me. Now, I had the duty, then I did not fulfill that particular duty. The damages were suffered by the client or the government, but there must be a correlation between the breach and the damages. Please understand this thing. And the proportionality is also required to be verified. That as I have breached this particular duty, which was casted upon me, this is the amount of damages suffered by the client or the government. Now, both are correlated. Now, if all these four stages I clear, then the case of professional negligence can be filed against me. So there must be a duty, there must be a breach of that duty, there must be damages, and the damages must be because of the breach of duty, and it must be proportionate. We cannot say that simply the client cannot say that you have signed this particular certificate, I produced that particular certificate, and then after I started incurring losses. One customer gone, second customer gone, my whole business gone, my brother's business also gone, my full family's business gone. So all these damages you are required to pay. No. It must be proportionate. It must be in the proportion of whatever breach of duty has occurred. This is about the civil consequences. Now, this is something interesting. I was searching for this particular case, this kind of case, when I was doing my law, and I got a very interesting judgment by Supreme Court, Jacob Matthew versus State of Punjab. Now, this is about the medical professions, but it is, as per my opinion, equally applicable for chartered accountants. This is about the criminal jurisprudence. Please understand this thing. A professional negligence case is filed against me. Now, what the other person is required to prove? The other person is required to prove, number one, this person, that means Mr. Brijesh Thakar, who claims to be a chartered accountant, does not possess the required skill of a chartered accountant, number one. So, if he proves that I am having a degree of CA, but still I don't possess the required skill, then the first stage is clear. Second thing, he said that no, this person is having the skill, but this person failed to exercise this particular skill in my case. So you had that required skill, but you didn't exercise that particular skill with reasonable competence. Then also you can be in trouble. You don't have that particular skill, you are in trouble. You have the skill, you didn't exercise, you are in trouble. But one fundamental question arises here. Before we go here, let me stop this sharing so that we can discuss it in an informal way. So before someone say that this person is not having the required skill, or this person is having the required skill but he failed to exercise those particular skills, then what is the benchmark? For example, Supreme Court here in this Jacob Matthews case clearly stated that the level of skill should be the reasonable and normal level of skill. What is the meaning of normal and reasonable level of skill? Extraordinary level of skill is not required to be exercised. They gave the medical example. Let's say you went for surgery to one doctor. He did that particular surgery and the patient died. Now the family members of that particular patient is claiming that this doctor to whom we give this particular patient, if we are going to some other doctor XYZ, let's say he's giving name of this some famous neurosurgeon, if we would have gone to that particular person, he would have applied a different approach and he could have saved this particular patient. Then Supreme Court said, no, this is not being done. You cannot simply say that the more skillful or more, let's say, a clever person or clever professional would have applied a different approach. That cannot be the benchmark. The benchmark can be a normal benchmark. For example, against Brijesh Thakar, let's say some cases find that you have not done that particular audit properly. If we would have given this particular audit to Remark, then Remark would have verified this thing also, that thing also, but you have failed to do this particular thing, then that cannot be the benchmark. You cannot compare me with someone who is having an extraordinary skill. It has to be compared with a person who is having a normal, reasonable skill. This is what has been clearly, categorically mentioned by the Supreme Court. So I think the professional negligence cases are clear in our mind. Let me start the screen sharing.
Brijesh bhai,
Yes, sir.
can we carve out our liability in non-attached function by some disclaimer or agreement type of thing with the client?
This is very important and interesting question. Now let's say when we are certifying something, because there is a difference between certificate and an audit report. In audit report, you are giving an opinion. But when we are certifying something as true and correct, in that particular situation, you cannot simply say that my liabilities are reduced. Because based on your certificate, if any action is taken, you might be having this idea that now institute is saying that to whomsoever it may concern should not be written on the certificate. You must address this thing to a party. Reason being, to whom this particular certificate is addressed, then your liability will be limited. But if you are writing that to whomsoever it may concern, then liability will be increased. But you can certainly limit your liability. You cannot simply remove the liability. You can simply write down that this certificate is given for this purpose. I have verified these things and my liability will be limited to this extent only. For example, I can give you the practice being followed in our office. We do not take up any assignment of any client without signing the consultancy agreement. Institute says that you are required to get into the engagement letter, etc., etc. We are going one level beyond. We are saying that we will sign a consultancy agreement, because I am not doing any attestation work or audit work, but still whatever consultancy I am giving, for that also we are entering into the consultancy agreement. In consultancy agreement, invariably we write down that the maximum liability of first part, that means our liability, will be limited to the amount of fees received by us, not more than that. So let's say based on my opinion or based on, let's say, the advice given by me, if you incur some loss, then in the worst to worst situation, I may need to refund you the fees, not more than that. So I can only advise you that whenever you are taking any assignment, then enter into a consultancy agreement, define the scope clearly. But as far as certificate is concerned, there we need to be very much careful. In the certificate itself, you need to write down. You cannot do it by way of another agreement or separate supplementary agreement. I think, is it clear, Riken bhai?
Yes, sir.
Okay. So the best practice is enter into an agreement. Standard agreements are available now. ChatGPT also drafts very good agreements. So Supreme Court said that civil and criminal negligence are different things. Mens rea must be present in case of criminal negligence, and degree of negligence must be very much higher. It may be gross or very high degree. Lower degree of negligence may only warrant a civil action. It will not warrant a criminal action. Now, next thing, so this is a summary, so we can skip this slide. Now let's come to the provisions of arrest. Now, why we are taking this arrest? Because let's say normal professional negligence situations are over. We can have the question answer afterwards on those particular area also. But arrest is also a very significant provision. When any person is arrested, the fundamental rights which are given to that person is same for the normal person also and for the professional also. What is the meaning of arrest? Then arrest is defined by Supreme Court in state of Punjab versus Ajay Singh. Now this Ajay Singh case, 1953, they are saying that arrest means a physical restraint put on a person as a result of allegation of accusation that he has committed a crime or offense of quasi-criminal nature. Please understand, arrest can be made only based on the accusation also. Conviction, trial, everything will be done afterwards. You can simply be arrested based on an allegation. That is the beauty of our criminal jurisprudence. Now let's come to this rights. If someone is arrested, what are his rights? First of all, right to legal counsel. So you can consult a lawyer or advocate of your choosing. Right to be informed. What is right to be informed? Why I have been arrested, grounds of arrest. And this will be informed to the family members and friends. And an arrest memo will be given specifying the charges, that these are the charges against you because of which you have been arrested. Now, two important articles we need to discuss here. Article 20 and Article 22. What Article 20 is saying? 3 fundamental rights are given by Article 20. Protection against ex post facto loss, meaning thereby, let's say today is 17th of January 2025. Now today they are saying that a person can be sent to jail for 7 years for XYZ offense, and you have been arrested. Now on 19th of January, they are amending this particular provision. And they are saying that for this offense, the punishment will be 10 years. So instead of 7 years, they are saying it will be 10 years. Then government says that now you have committed this particular offense. Earlier it was 7 years. Now you will be sent to jail for 10 years. Then that is not possible. The moment at which I committed that particular offense, at that time, whatever was the penalty or whatever was the imprisonment or punishment, we call it, only that much will be applicable to me. It cannot be increased afterwards. So post facto, ex post facto amendments will not be considered effective for these criminal things. Now, one very interesting question may come. Let's say for X offense, when I committed that particular offense, the punishment was 7 years. They amended it afterwards and made it 4 years. Then whether to me 7 years will be applicable or 4 years will be applicable? What should be applied to me?
4 years.
4 years. Now this answer is not given in Article 20 because Article 20 only says that if it is increased afterwards, it should not be applied to you. But if it is decreased afterwards, whether you will be given the benefit or not, that question is not answered by the Constitution, but it has been answered by the Supreme Court. Supreme Court says that ultimately fundamental rights are given for the benefit of the person. So if afterwards the punishment is reduced, that benefit should be given to everyone. But if the punishment is increased, that particular thing should be applied only to a person who is committing the offense afterwards, not to the person who has already committed that offense. Second thing, protection against double jeopardy. Double jeopardy means what? For the same offense, I cannot be prosecuted and punished twice or more than once. It is not twice, but more than once. So this we all know. Protection against self-incrimination. Now, this is very important fundamental right. They cannot force me to be a witness against myself. They cannot force me to sign a statement. They cannot force me to confess something. This kind of forces, whatever are that they cannot apply on me. That means merely based on my statement, punishment cannot be given to me. This is what they are saying. Now, in law, there is one interesting subject of what we call this narco analysis and this kind of tests, whatever are being done, or this narco analysis are also there, lie detector test, etc. Now, Supreme Court had an opportunity to verify the enforceability of this test. Suppose, let's say, a narco test is given or is applied on me. In the narco test, or let's say on the lie detector test, I am confessing an offense. Then please understand, Supreme Court has categorically stated that whatever I am saying under the influence of drug also, or let's say under the influence of this narco test, etc., that cannot be considered as admissible evidences, because it is violative of this Article 20 bracket 3. It is self-incriminating. So narco test, etc., can be used only at the investigation stage, not at the trial stage. So for investigation, etc. For example, let's say in the narco test, you can ask a person where you have hidden this weapon of murder. And that particular person will say that I have hidden this particular weapon of murder as XYZ place. Now police go there and they find that particular weapon. That much usefulness will be there for the narco analysis. But if in the narco analysis, police is asking that you have killed this particular person, yes or no, and you are saying that yes, I have killed this person, then this confession will be of no use in the court of law, because it will be violative of Article 20 bracket 3. So your own confessions will be of no use for doing the trial. This is what Article 20 is saying. Now 22. 22 is also very important fundamental right for arrest and detention. Right to be informed of the grounds of appeal. The moment you are arresting someone, you need to inform him the grounds of arrest. Please understand, Supreme Court has recently, I think in 2015 or 14 or in some year, differentiated the grounds of appeal versus reasons for arrest. Grounds of arrest versus reasons of arrest. They are saying that you are not only required to give the reasons for arrest, you are required to inform him the grounds of arrest. So without informing the grounds of arrest or grounds for arrest, a person cannot be arrested. And within 24 hours of the arrest, you are required to be produced before the magistrate. And magistrate will decide whether this person will be continued in the judicial custody or remand is required to be given, or he will be released. That will be decided by the magistrate. Exceptions, we are not going into exception because it is the enemy alliance and preventive detection. These are all the prevention of terrorism activities. For that, exceptions are there. So not of any use. So limitations on the power of arrest, they are saying it is violative of sometimes fundamental right, life and liberty under Article 21. It cannot be exercised mechanically. And the constitutional safeguards given under Article 20 as well as 22 must be adhered to before arresting a person. Now, this is in 1994 Supreme Court has observed, and this is also one very interesting observation. Supreme Court says no arrest can be made because it is lawful for the police officer to do so. The existence of power of arrest is one thing. The justification for the exercise of it is quite another. That means you may be having the power. That doesn't mean that you keep exercising that power. No arrest should be made without a reasonable satisfaction reached after some investigation about the genuineness or bona fide of a complaint, and a reasonable belief both as to persons' complicity and even so as to the need to effect the arrest. Denying person his liberty is a serious matter. So this is what they are saying, that you need to first of all satisfy yourself that this person has actually committed this crime, and without arresting this person, the proper investigation cannot be made. If you are not having that satisfaction, even if you are having the power to arrest, don't exercise this power. This is what Supreme Court has said. Yes, the difference between reasons for arrest and grounds for arrest. Now, reasons for arrest means what? They can simply come to your premises and arrest you. And you say, give me the reasons for my arrest. That means they are saying that we feel that you have committed this crime, and we arrest you so that you don't further commit this particular crime, or we can have the proper investigation. If they are giving reasons like this, that for proper investigation we want to arrest you, or to make you not commit this crime again, we are arresting you, these are not called grounds of appeal. Grounds for arrest, sorry. Grounds for arrest means a different thing. Grounds for arrest means a detailed reasons that why you are being arrested, what are the charges against you, how they are saying that you have done this particular activity or this particular offense. That is called ground for arrest. So reason for arrest is different from grounds for arrest. In many of the cases, the police officer or the other officers, enforcement officers, are only providing the reasons for arrest and not providing the grounds for arrest. Now, Supreme Court judgment, yes, this 2024 15 May judgment, very interesting judgment, where this NewsClick founder, editor-in-chief, was arrested. And Supreme Court said that the full arrest is illegal. Why? Because the person was only supplied reasons for arrest and he was not supplied with the grounds for arrest. So if the grounds for arrest is not supplied, that means the arrest is illegal. So why grounds of arrest is required to be conveyed? First of all, if I am not given the grounds for arrest, how will I prepare my defense? If I want to go for bail application without knowing the exact charges, I cannot go for the bail application. And my constitutional rights are also violated. Without giving me the proper grounds, they cannot arrest me. So these are the key takeaways for arrest provisions. Constitutional protection will be there. Judicial oversight will be there. Judiciaries must have the proper checks and balances. Reasoned arrest must be reasoned. Accused must be informed and he must be given the right to defend himself. So he must be given the right to defend. So these are the principles on which the arrest provisions are based. Yes, there are certain other judgments also, DK Basu versus State of West Bengal, where in detail guidelines are given by Supreme Court. When a person is arrested, his medical examination should be done, his photograph and name should be there in the police station, his family member must be informed, etc. It's a long guidelines is there, but I have not taken that much things into this presentation. Now about the arrest provisions in GST and PMLA. Because as far as the financial professionals are concerned, these are two very dangerous law. PMLA, the most dangerous law. GST also to some extent. Where the provisions for arrest, section 69 and 132. Section 69 gives powers to the GST officers to arrest a person for tax evasion, allegation of tax evasion. And 132 is about the prosecution. Now, at present, Supreme Court is hearing the petition where the argument is both this section 69 and 132 are violative of Article 21. And second thing, whether the powers of arrest can be reconciled to Article 246 capital A or not, because GST is coming into existence through Article 246 capital A. Now, Article 246 capital A only talks about the imposition of tax on supply. So whether arrest provisions are also part of that or not, that is required to be checked, because the argument from the officers are that we are not required to follow the CRPC, Criminal Procedure Code. We are not required to follow because it's specific law. GST law is special law. So without following that particular provisions and procedure also, we can arrest a person. So at present, this issue is pending before the Supreme Court, whether these arrest provisions are constitutionally valid in GST or not. Now, this is something very dangerous, something out of the world. PMLA arrest provisions, section 19 and section 45. This provisions of PMLA violates all the established jurisprudence. And still, interestingly, Supreme Court upheld the constitutional validity. Now, Supreme Court is also revisiting this issue in different individual cases. Power to arrest ED officers. So here, ED officers can arrest a person when they are having a doubt that a proceeds of crime is involved. So money laundering has happened. And section 45 is giving a stringent bail conditions. What they are saying, that the court is required to be satisfied that the accused is not guilty of an offense. Only then a bail will be given to him. Normally what happens, normal provision is a person is considered innocent until proven guilty. Here the things are reverse. If court is satisfied that you are innocent, only then bail should be given. This is what section 45 of the PMLA is saying. Now, the most dangerous section of PMLA, section 24, burden of proof. Now, normally what happens when any person is arrested or any allegation is made on that person, then the person who is making the allegation or the person who is arrested or the enforcement agencies are required to prove that this person has committed this offense. Here, section 24 imposes a reverse burden. That means I am required to prove that the asset that has been created by me is not out of the proceeds of crime. So the burden of proof is on the accused. Now this ultimately, the law has its root in the 11th and 12th century. And in the 11th and 12th century onwards, the fundamental provision is the person who is making the allegation is required to prove, not the person on whom the allegation is made. Tomorrow someone is saying that I have made something, I have made some offense. Then I am not required to prove that I have not made that offense. They are required to prove that I have made that offense. But under PMLA section 24, the burden is on me that I am required to prove that I have not committed that offense. So this is something dangerous, something different from the established jurisprudence. Reverse burden, presumption against the accused, and they are saying that whatever amount is recovered from you, whatever assets are recovered from you, they are assuming that is proceeds of the crime. Next, judicial observation. In case of Vijay Madanlal Chaudhary's case, 2022, Supreme Court interestingly said something which we don't expect from Supreme Court. It stated that money laundering is a serious offense that necessitates stringent measures, including the reverse burden of proof. The court emphasized that the provision is consistent with the international anti-money laundering standards, including those of Financial Action Task Force. It may be consistent with the Financial Action Task Force recommendation or international money laundering standards, whatever. It is not consistent with the established jurisprudence in India. So naturally, it is violative of Article 21. It is obviously violative of Article 14. But it is what it is right now under PMLA. We say that it is violative of 14, 19, 21. These are excessive powers. Why excessive powers? In one of the cases, the court went ahead and said that normally what happens whenever you are arrested and then after you are produced before the court and when the trials, before commencement of the trial, you must be given the copy of the FIR, first investigation report. In ED cases, it is Enforcement Case Information Diary, ECID. So that ECID is equal to FIR. But court said that ED officers are not police officers. So police officers are required to produce the copy of FIR, but they are not required to produce. The ED officer not required to give you the copy of the Enforcement Case Information Diary. So this is something very strange. So these are some of the problems in PMLA. Constitutional validity upheld. They are saying it's distinct from criminal law. ED officers are not police officers. That's why they are not required to follow the provisions which are required to be followed by the police officers. The judgment has been widely criticized. But now Supreme Court in different cases are coming up with different approach, that even if the reverse burden is there, but still a person is required to establish, that means the enforcement officers are required to establish the prima facie cases, etc. These kind of things are said by the court. We don't know in which direction this will go. It is an ongoing debate and criticism is there. Let's not go into this detail because we have fundamentally understood this. Ultimately should be, they are saying that the national interest is at stake, but national interest may be at stake. But you cannot violate fundamental rights of a person in the name of national interest. So these excessive powers must be checked by the courts. Okay, once we have concluded up to PMLA, now question remains, if my fundamental rights are violated, where can I go? If your fundamental rights are violated, you can directly approach Supreme Court under Article 32. And another remedy is also available. You can go to High Court under Article 226. Please understand one important difference between Article 32 and 226. Article 32 is covered under Part 3 of the Constitution. as it is covered under Part 3 of the Constitution, it is a fundamental right. That means going to Supreme Court for enforcement of my right itself is my fundamental right. Whereas going to High Court is not my fundamental right because it is not covered under Part 3 of the Constitution. So under Article 226, you can go to High Court for, let's say, enforcement of fundamental rights also and for other reasons also. So Article 226 is having a wider scope in comparison to Article 32. Article 32, you can go for enforcement of the fundamental rights to Supreme Court directly. So these are the options available with us when our fundamental rights are violated. You can directly go to the constitutional courts. Nothing much to discuss here. ICAI's role, because day by day ICAI's role is being shrinked. They can give you the professional ethics and the guidance that what are the ethics you need to follow, what are some of the guidelines that you need to adhere to while executing your work. We can expect a fair disciplinary process from the ICAI, but many of the things are not in the hands of ICAI. We all need to accept that. So I leave it here as far as ICAI's role is concerned. What we recommend is transparency. Maintain a clear and detailed documentation in your professional engagement. What can save you? A clear and detailed documentation, we normally call it an agreement, consultancy agreement. Respond promptly and proactively to legal notices or summons, but respond only to the questions which are asked. And you can challenge that particular notice also in the court of law directly. And seek legal counsel promptly. And advocate for fair treatment through ICAI and other courts. So whenever you feel that some criminal case may also be filed against you, directly consult a proper lawyer. Legal advice must be taken. But before you take the legal advice, you also need to have the understanding of your own fundamental rights. So prima facie, in which direction the wind will go, that you can understand. So this is the conclusion. We must be aware about our rights and responsibilities. Constitution can guarantee you fairness and justice, but ultimately we need to implement it. We need to enforce it through courts sometimes, through awareness sometimes, through discussions sometimes, by whatever means. But ultimately these are the rights given by the court. If we are aware of the rights, then we can have a better future and a safe future. So that's it from my side. If any questions is there or any other discussion needs to be done, we are open for that.
Brijesh bhai, I think there is one question from Darshan bhai regarding this right to property.
Can you comment on why property removed from the fundamental rights? Presently, huge debates are going on the land acquired Waqf board. Waqf board claims any land as its own. Had property ownership be a fundamental right, would it be possible for Waqf board to claim any land? See, I will not go into a discussion about the Waqf board and etc. It will be a kind of political discussion. I can discuss the constitutional things. I told you at that particular time also why it was removed. It was removed because the argument was, if right to property is given as fundamental right, then government's hands will not be reached to properly implement the equality, because ultimately it was done to give land to farmers. So if from landlords, if they cannot snatch away that particular land, it cannot be given to the person who is cultivating the land for the ages. So that was the argument, a socialism concept. That's why it was removed from the fundamental rights under Article 31. If you see the discussion under Kesavan Bharti versus State of Kerala, what they did, because in Golaknath case, the Supreme Court said that you cannot simply change the constitution. And Article 13 bracket 4, fourth number point, fourth sub article we call it, that fourth clause or we call it, that was inserted. And it said that the Constitutional Amendment Act passed by the Parliament cannot be considered as law as far as this part is concerned. Because Article 13 was saying that law means what? Any law passed by the Parliament, any rule made by the government, any regulation made by the government, everything is law. Nothing can be against this particular part. So if let's say by exercising powers under Article 265, if they remove some of the fundamental right, in that situation, it will be violation of Article 13. So they change Article 13 and said that Constitutional Amendment cannot be called law. So we can, through Constitutional Amendment, remove the fundamental right. But Supreme Court said in Kishore Bharti versus State of Kerala, yes, this Article 13(4) is constitutionally valid. There is no doubt about that. But in the name of constitutional amendments, you cannot simply rewrite the Constitution. But Supreme Court upheld the removal of right to property as fundamental. It is, we call it that Supreme Court is not final because it is right, but Supreme Court is right because it is final. So whatever has been said by the constitutional bench of the Supreme Court, then after we cannot go ahead. So ultimately this Waqf discussion perhaps ends here. Yes, sir. Anything else?
There is one further query. Can Article 23 come to rescue where disclosure is made during the search or survey? It is meant for protection in the criminal proceedings.
See, please understand one thing. In the CRPC also, now Bharatiya Nyaya Sanhita, some this kind of Hindi conversion is there, where they are saying that in the CRPC itself, it has been said that whatever confession you are making to the police officer, it cannot be considered as evidence in the court of law. It has to be in front of the magistrate. Now, any disclosure you are making during search or survey, etc., it cannot be considered as evidence. Per se, it can never be considered evidence in the court of law. Corroboratively, it can be used. For example, in the search, you are saying that I have made this kind of offense and the proceeds of that particular crime is hidden here. Now they search that particular premises and they got that particular cash. Now whatever statement you have given, that becomes of importance for that person. But only your plain statement, plain confession will be of no use. So Article 20(3) will definitely come to your rescue. Yes, anything else?
યસ બ્રિજેશભાઈ, એક મારી ક્વેરી છે.
હાજી.
આપણે ક્લાયન્ટ પાસેથી ફી લેવાની બાકી છે સીએને, તો એ આર્ટિકલ 19 માં આવી શકે કે કેમ?
નહીં, આર્ટિકલ 19 માં નહીં આવે. પ્લીઝ અન્ડરસ્ટેન્ડ. એક તો આર્ટિકલ 19 જે છે ને, ઇટ ઇઝ એન્ફોર્સેબલ અગેન્સ્ટ ધ સ્ટેટ. બરાબર છે, ઇટ ઇઝ નોટ એન્ફોર્સેબલ અગેન્સ્ટ ધ ઇન્ડિવિજ્યુઅલ, જસ્ટ લાઈક આર્ટિકલ 21. એટલે પ્રાઇવેટ પર્સનની સામે એ એન્ફોર્સેબલ નથી. નંબર 1. તમે એવું કહી શકો કે પ્રાઇવેટ પર્સનની સામે કે આણે મને પૈસા નથી આપ્યા, એના કારણે હવે મારું બિઝનેસ ચાલી શકે એમ જ નથી ચાલી શકે એમ, એના કારણે મારે માટે જીવવું જ મુશ્કેલ છે. In that long route, you can go to Article 21, but not under Article 19. But I will suggest the better options are negotiable instrument tax will be there, the signed check is there, 130. એ બધી પ્રોવિઝન્સ છે ડાયરેક્ટલી, ઇન્સ્ટેડ ઓફ ગોઈંગ ડાયરેક્ટલી ટુવર્ડ્સ આર્ટિકલ 19 અને આર્ટિકલ 21. હા, તમારે એવું પર્પઝ હોય કે આર્ટિકલ 19 અને 21 નો યુઝ કરીને હું સીધો હાઈકોર્ટમાં જઈ શકું એટલા માટે, કારણ કે સિવિલ સૂટ ફાઇલ કરીશું કોર્ટમાં તો કેટલાય વર્ષો જશે. પણ હાઈકોર્ટ તમને એમ જ કહેશે, તમે આવો કેસ ફાઇલ કરશો કે મારા આર્ટિકલ 21 નું વાયોલેશન છે કે 19 નું વાયોલેશન છે, તો કોર્ટ કહેશે કે અલ્ટરનેટિવ એફિકેસીસ રેમેડીઝ અવેલેબલ. નોર્મલી વોટ હેપન્સ, જ્યારે તમે રીટ પિટિશન ફાઇલ કરો છો ને હાઈકોર્ટમાં અથવા તો સુપ્રીમ કોર્ટમાં, ત્યારે નોર્મલી સુપ્રીમ કોર્ટ કે હાઈકોર્ટ અગર એ પિટિશન સ્ટેટની સામે હોય તો સાંભળશે. અગર ઇન્ડિવિજ્યુઅલ પ્રાઇવેટ ઇન્ડિવિજ્યુઅલની સામે હશે ને તો પહેલા જોશે કે બીજી રેમેડી હશે જ અવેલેબલ એની માટે. તમને કહેશે કે ભાઈ એફઆઈઆર ફાઇલ કરાવો, ક્રિમિનલ પ્રોસિજર કોડમાં જાઓ, સિવિલ સૂટ ફાઇલ કરો એની સામે. ત્યાં તમને રિસ્પોન્સ નથી મળતો, લેટ્સ સે પોલીસ ઇઝ નોટ ડુઇંગ એની એક્શન, એ કેસ મારો બોર્ડ ઉપર આવતો જ નથી, જેના કારણે મારો બિઝનેસ નથી ચાલી રહ્યો, તો બીજા બધા જે ઓપ્શન્સ છે એક્સરસાઇઝ કરી ચૂક્યા છો, સ્ટીલ યુ આર નોટ ગેટિંગ વોટ યુ વોન્ટ, then you go to High Court or Supreme Court. But agar if it is required to be enforced against the state, go directly to High Court or Supreme Court. Right?
Can non-payment of fees be a ground to restrict the professional liability in case of consultancy?
It can be, but ultimately depends on the agreement. Because what happens, જ્યારે સૌથી સેફ આપણે ક્યારે રહીએ રિકેનભાઈ, મારા ઓપિનિયન પ્રમાણે, તમે એક એગ્રીમેન્ટ કર્યું છે, એમાં લખ્યું છે કે મારી લાયબિલિટી આટલી છે, પણ થર્ડ પાર્ટી એ તમે લાયબિલિટી તમે રેસ્ટ્રિક્ટ કરો છો ક્લાયન્ટ માટે. સપોઝ એ જ વસ્તુ જવાની છે ગવર્મેન્ટ માટે, તમારા એગ્રીમેન્ટ થી એ લાયબિલિટી ગવર્મેન્ટ માટે રેસ્ટ્રિક્ટ નહીં થાય. તમે એમાં ઇન્ડેમનિટી ક્લોઝ એડ કરી શકો કે ભાઈ આવું કરવાના કારણે મારી ઉપર કંઈ આવશે તો યુ નીડ ટુ ઇન્ડેમનિફાય. પણ એ સેપરેટ સિવિલ સૂટ થશે ક્લાયન્ટની સામે. હા, તમે લખી શકો મને ફી નહીં મળે તો મારી લાયબિલિટી આટલી રહેશે, પણ એ કોના સામે? ક્લાયન્ટ સામે, જે એગ્રીમેન્ટનો પાર્ટ છે એની સામે. Not towards the third party who is going to use your certificate, not towards the government who is relying on your certificate. તમે ક્લાયન્ટને તો રેસ્ટ્રિક્ટ કરવા માટે તમારા એગ્રીમેન્ટમાં કંઈ પણ લખી શકો છો ને કંઈ પણ રીતે એને રેસ્ટ્રિક્ટ કરી શકશો. પણ અહીંયા ક્વેશ્ચન મોટો એ ઉભો થાય છે કે આ ફક્ત ક્લાયન્ટનો પ્રશ્ન નથી, ગવર્મેન્ટનો પ્રશ્ન છે, પબ્લિક લિમિટેડ તમારી લિસ્ટેડ કંપની હોય તો પબ્લિકના પૈસાનો પ્રશ્ન છે. એ લોકોએ તમારા બે વચ્ચેનું એગ્રીમેન્ટ નથી વાંચ્યું. They are simply relying on the audit opinion you are giving or the certificate you are giving. Yes, anything else? Well, actually, can ED or CBI can detain CF of a company to extract critical information of the company without any prior notice. See, please understand. જ્યારે આપણે એવો શબ્દ વાપરીએ detain is ultimately an arrest. તો તમારા પાસે આર્ટિકલ 20 પણ છે, આર્ટિકલ 22 પણ છે, અને ડીકે બાસુ વર્સિસ સ્ટેટ ઓફ વેસ્ટ બેંગાલના ગાઈડલાઇન્સ પણ છે. એમાંથી કંઈ પણ વસ્તુનું વાયોલેશન થયું હોય તો ડાયરેક્ટલી એપ્રોચ ટુ સુપ્રીમ કોર્ટ ઓર હાઈ કોર્ટ. વી કેન નોટ સિમ્પલી આન્સર કે વેધર ઈડી કે ઓર સીબીઆઈ કેન ડિટેન ઓર નોટ. હા, એ પ્રોસિજર એમણે ફોલો કરે છે, દેન દે કેન વેરી વેલ ડુ ઇટ. The only thing we need to understand is કે ક્રિટિકલ ઇન્ફોર્મેશનમાં એમને કેમ લાગે છે કે તમે આ ક્રિટિકલ ઇન્ફોર્મેશન છુપાવશો, એના કારણે આ ઓફેન્સ જે છે સરફેસ ઉપર નહીં આવે, તમે ઓફેન્સમાં ઇન્વોલ્વ હતા, ગ્રાઉન્ડ્સ ઓફ એરેસ્ટ તમને જે આપશે એમાં વસ્તુ લખેલી છે. બટ વિધાઉટ પ્રાયર, સી ફોર એરેસ્ટ they don't need to give you notice. Arrest means they will simply come to you and they will give you the arrest memo and grounds of arrest. Because there is a concept under CRPC, noticeable offense and non-noticeable offense. કેટલાક ઓફેન્સ એવા, આમાં શું કહેવાય, આપણે આ પોઈન્ટ લીધો નથી છતાં પણ નોર્મલ અન્ડરસ્ટેન્ડિંગ માટે કોગ્નિઝેબલ ઓફેન્સ હોય ને નોન કોગ્નિઝેબલ ઓફેન્સ હોય. કોગ્નિઝેબલ ઓફેન્સની અંદર તમને વોરંટ વગર એરેસ્ટ કરી શકે પોલીસ ઓફિસર. જ્યારે નોન કોગ્નિઝેબલ ઓફેન્સ હોય તો કોર્ટનું વોરંટ હોય તો જ પોલીસ ઓફિસર એરેસ્ટ કરી શકે તમને. હવે કોને કોગ્નિઝેબલ કહેવાય, કોને નોન કોગ્નિઝેબલ કહેવાય, એ ફર્સ્ટ શેડ્યુલ ઓફ સીઆરપીસી માં આપ્યું છે. મેઇનલી એવું છે, કોઈ પનિશમેન્ટ અગર 3 વર્ષથી વધારે સમયનું હોય તો એ કોગ્નિઝેબલ છે, સિરિયસ ઓફેન્સીસ. તેમાં કોર્ટના વોરંટની વેઇટ નહીં કરે પોલીસ. અને 3 વર્ષથી ઓછું અગર ઇમ્પ્રિઝનમેન્ટ છે તો એ નોન કોગ્નિઝેબલ છે, કે કોર્ટના વોરંટ વગર તમને એરેસ્ટ નહીં કરે. પણ એમાં પણ પાછું એક એક્સેપ્શન છે કે જો ઓફેન્સ કોગ્નિઝેબલ હોય તો તમને એરેસ્ટ કરી જ લેવા એવું જરૂરી નથી. 7 વર્ષ એટલે 3 વર્ષથી વધારે છે ઇમ્પ્રિઝનમેન્ટ, પણ 7 વર્ષથી ઓછી છે ઇમ્પ્રિઝનમેન્ટ, then that is called noticeable offense. એમાં તમને પોલીસ ઓફિસર કે ઈડી કે સીબીઆઈ માત્ર નોટિસ આપશે, તમને એરેસ્ટ નહીં કરે. પણ જો એવા કેસમાં અને 7 વર્ષથી વધારેની ઇમ્પ્રિઝનમેન્ટ હશે તો એ લોકો એરેસ્ટ કરશે. જો 7 વર્ષથી ઓછી ઇમ્પ્રિઝનમેન્ટ છે ને એમણે એરેસ્ટ કરવા છે, then they are required to record the reasons for arrest, કે કેમ નોટિસેબલ ઓફેન્સમાં પણ મેં એમને એરેસ્ટ કર્યા છે. સો આવું છે ફંડલ સમરી. કન્ફ્યુઝ થઈ ગયા હોય તો સમજી લઈએ. 3 વર્ષ કે 3 વર્ષથી ઓછું હોય તો કોર્ટનું વોરંટ હોય તો જ એરેસ્ટ થવાય, એ વગર એરેસ્ટ થવાય. 3 વર્ષથી વધારે હોય તો કોર્ટના વોરંટ વગર પણ એરેસ્ટ થઈ શકાય. પણ 3 વર્ષથી વધારે, 7 વર્ષથી ઓછું તો એરેસ્ટ થઈ શકાય તો પણ પોલીસ તમને એરેસ્ટ નહીં કરે, નોટિસ આપીને છોડી દેશે. કે હું કહું ત્યારે બોલાવું ત્યારે હાજર થજો, ઇન્વેસ્ટિગેશન માટે સ્ટેટમેન્ટ આપવા માટે હાજર રહેજો, એવું કહેશે તમને, રાઈટ. પણ તો પણ તમને એરેસ્ટ કરવા છે તો એ લોકોએ રીઝન રેકોર્ડ કરવું પડશે કે ભાઈ 3 થી 7 નો ગાળો છે તો પણ કેમ તમને એરેસ્ટ કરે છે. અને 7 વર્ષથી વધારે વાળું હશે then you are in trouble, કે they will arrest definitely. કારણ કે 7 વર્ષથી વધારે વાળું હોય તો કેવા કેસીસ છે, કે ગ્રીવસ હર્ટ હોય, રેપનો કેસ હોય, મર્ડર છે, આ બધી વસ્તુઓ છે, રાઈટ, કલ્પેબલ હોમિસાઇડ છે, then police will definitely arrest. Yes. Anything else?
So I think with this, we call it a day, and I request the committee members to please take the charge further.
Yeah. Thank you. Thank you for this wonderful lecture. I think we have gone even beyond constitutional and got to know even further about criminal procedures as well and civil procedures as well. So thank you very much for this wonderful session, and thanks to all the audience members for listening carefully. Thanks a lot.
Thank you.
Thank you, Brijesh bhai.
Thank you. Thank you.
Thank you.
Yeah. Thank you, Brijesh.
Thank you, sir. Thank you, Brijesh.